The ruling stems from a case filed by two Escondido teachers. They claim their district policy preventing them from disclosing their students' gender identity infringes on their First Amendment rights. The parents also joined the lawsuit, saying these policies undermine their ability to raise their children according to their beliefs. In December, San Diego federal judge Roger Benitez sided with them. The Ninth Circuit Court of Appeals paused that decision while they review the case. The plaintiffs then asked the Supreme Court to reinstate the lower court's decision. Late yesterday, the court majority agreed.
That's why this was such a very, very interesting and very important ruling.
The Supreme Court has generally given broad deference to parents under the 14th Amendment. According to San Diego legal analyst Dan Eaton, the ruling says school officials can't mislead parents about their children's gender.
Because if withholding information about a child's transitioning and their use of pronouns inconsistent with their birth assigned gender would in some way mislead the parents, the teachers are going to have to disclose that information.
The Supreme Court ruling did not lift the injunction for teachers. That is creating confusion over what it means for the Safety Act. The law bars school districts from requiring teachers to notify parents if their students choose to go by a new pronoun at school.
With respect to our bill, we're actually not sure because there's a lot of ambiguity in the ruling.
Assemblymember Chris Ward is the author of the Safety Act. He believes the law remains in effect, but
We're deeply concerned about what this conservative supermajority on the Supreme Court is doing generally for national policies, but also specific to these threats on the LGBTQ community. This was never about secrecy. It was about ensuring that educators aren't becoming agents of compulsory disclosure.
the Thomas More Society praised the ruling, saying it protects children and families. The group helped mount the legal challenge in this case. But a statewide educators union opposes the ruling. They say it creates a forced outing policy, which puts students' safety at risk. Jeff Freitas is the CFD president.
What we're seeing is a continuing and ongoing attack and silencing of the LGBTQ plus community. And we believe that this is harmful for our students in our schools.
The Supreme Court's ruling means that Judge Benitez's injunction against the state policy is now in effect until the Ninth Circuit Court of Appeals has a chance to review the case. Eden says that was part of the reason for the Supreme Court's emergency decision.
Regardless of what the Ninth Circuit ultimately does, you can expect that the Supreme Court will weigh in on this case.
Which means this issue is far from over. Alexander Nguyen, KPBS News.